Hello everyone, welcome to Court with Krissy. This sentencing obviously does not go the way the defendant was hoping. And while it's not Taylor Schabusiness lunging at her defense attorney before being tackled by 6 or several bailiffs explosive, it's still explosive, and I think you'll like it. Court with Krissy is now in session.
The counsel are still here, and Mr. Wilson has now rejoined us here in the courtroom. We're here today for sentencing in each of these two files. Actually, one file and the other file is being dismissed, which I have a knowledge cross presented to me by Mr. Defendant. One moment. We were last here on the record back on March 3rd of this year. The court entertained arguments, allocution, challenges to the pre-sentence investigation report, scoring of the guidelines. In fact, the court got all the way down to allocution by the defendant himself. The court allowed a very extensive allocution. I understand that, and of course the court had to adjourn the sentencing because, and I understand that there has been some communication with the court since then through from the defendant through counsel and so forth, but just for the record, we'll say that there were some interruptions and the court felt we just needed to move on because we already spent nearly an hour on that sentencing. All right, so now we're here at this point, and I want to take a look here at a few things that we need to update. The court has received, and I want to make sure for the record that the prosecutor has them. Number one, on April 1st, which was just last week, the court received a letter from Addiction Treatment Services stating that Mr. Wilson is currently on a waiting list to enter Decoski Hall. The court also received a letter dated March 24th of this year from Ms. Platts of Catholic Human Services, who helps conduct group treatment here at the Missaukee County Jail. I received that letter. The court also received a letter dated March 27th of 2025, purportedly presented or written by the defendant. I did review that this morning. There also was an updated pre-sentence case report on a CFJ 413 presented by the Department of Corrections. Now that was presented in its own letter dated February 10th from Addiction Treatment Services, again asserting that he has been on it or has been added to a wait list at their program. And also there was a letter dated March 11th of 2025, handwritten by the defendant, Mr. Wilson. Mr. Denhouten, have you received all those materials?
I have received all those materials, Your Honor, and I have reviewed all those materials prior to the hearing today.
Thank you very much. Mr. Champion, did I cover them all correctly? I want to make sure I didn't miss any other.
I believe that you've covered everything. The only additional minor update to that is that Mr. Wilson has completed the 10-session certification of corrections from Ms. Platt as part of the treatment program. So,
all right. Thank you. Oh, I should also note that the court last time found the defendant in contempt for failing to comply with the court's request to have him stop talking as the court sought to maintain control of the courtroom last time. Now, so we're just going to jump to sentencing because I've already heard it and I've already heard allocution and I already have a lot of information that's even been presented and which I've received no objection to, and I will consider that. Mr. Wilson mentioned in his letter an apology, and I appreciate that. The court understands and looks back and says, anytime someone is here facing potential prison, it gets very difficult. And there's a lot of emotion for people who have had issues, have tried, have failed, that continue to try, and have had significant challenges in their life. So I appreciate that. And I understand that in one of these letters, Mr. Wilson mentioned that he recognizes he had his chance to speak. And again, I think that was the longest allocution I've ever received or entertained from a defendant at sentencing. And this is a case where we have an assault resist and a possession of methamphetamine. He worried, as he said here in writing, quote, "My worry is that all of what I had to say is now gone and forgotten and over." No, I remember it. Again, it was definitely the longest allocution I've ever heard from a defendant. And I recognize that the defendant was quite emotional. And I'll tell you, also, I'm sorry, one moment. He also said something in this letter that he thinks I've already made up my mind. I haven't. I don't really know what to do with Mr. Wilson. When I look at what Mr. Wilson has here, number one, he was on parole, had just been let out of prison when these events occurred. He went straight back to committing the same type of conduct. And I know he spent 14 years in prison for an armed robbery. And he was paroled on January 30th of 2024. And again, immediately went back to violating. I have got a lot of writing on this copy of the pre-sentence investigation report. You know, he had been in prison for such a long time. I would have hoped that he would have put his past of drugs behind him. But after 14 years, he went right back to it. And he was back to meth and back to cocaine quickly. Also, when I look at the rest of the report, I know there was a request for 7411 somewhere mentioned in there. The court's not going to put the defendant on 7411. His repetitive violations of probation and parole and so forth tell me that. When the Department of Corrections asked the defendant to explain his conduct, he came up with the phrase that he was institutionalized. And I don't know if I disagree with that, but it also said that, quote, "The defendant was previously instructed to enroll and attend counseling sessions to address mental health issues, but failed to follow through." I underlined that a couple times. Next, it also said, quote, "The defendant has demonstrated an explosive temper and, for a lack of a better word, throws a tantrum when he is told something he doesn't want to hear," end quote. Well, the last court session definitely highlighted that for me. Admit here that says, "The defendant completed and returned the pre-sentence paperwork as requested, but," which I circled, "when questioned, provided little information or insight regarding his upbringing, stating we had already have all this information in the system," end quote. Then it also said that, quote, "During the interview, the defendant presented as generally sullen and angry," end quote. They continued to say that, quote, "Despite several efforts to guide the defendant in a positive direction toward his goals for the future, he continued to revert to how they don't want him out of prison. Nobody cares about him. and this writer doesn't want to supervise him. It continued to say, quote, the defendant stated numerous times if he is returned to prison, he will commit suicide. Then it continues, and I just put down, this is really difficult. This is difficult, and I just said the word terrible. Quote, after several attempts to positively redirect his thought process, the interview, which included leaving the room and notifying corrections officers. The defendant then refused to leave the room when instructed by Lieutenant Harwood, resulting in correctional officers having to handcuff him and escort him back to a cell. A few hours later, the defendant began to act out again and had to be placed in a restraint chair. There's another portion here where it talks about, and I understand his mother stands by him. That's great. Mothers always do. And that's what mothers are supposed to do. And I'm very glad to see that from his mother, Michelle. She says that, quote, but feels prison is not the right answer, end quote. Generally, sometimes prison is necessary. Rehab is a good opportunity. I've got these letters here from Addiction Treatment Services, and I want to send people to Addiction Treatment Services whenever I can. Underneath the recommendation on CFJ 284, page 3, it states, quote, the defendant takes no responsibilities for his actions and has not been able to demonstrate self-control, end quote. Also, it says, upon review of the defendant's behavior while incarcerated in max DOC facilities, Mr. Wilson demonstrates his continued negative behaviors, including assaults on the staff. Then we will look here at the description of the offense back on December 3rd of 2024. It says the defendant's living area in the basement was searched with several folding knives and a hatchet discovered, and substantial quantities of ammunition and loaded magazines, which of course he's not permitted to have. He also tested positive. When challenged by Sergeant Vorpagel of the Missaukee County Sheriff's Department, the defendant said he was not going to jail. He ran into his bedroom and shut the door. Noise could be heard coming from the room, and it didn't respond to attempts to communicate. That is a very dangerous situation to a person who doesn't want to go back to jail or prison, who knows that he's violating the rules, who doesn't care to comply with the rules, and is out possessing firearms and ammunition when he knows he is not permitted to possess them. Then when we look here, we find that we had, the defendant had Suboxone, wrappers, syringes, controlled substances, tourniquets, tested positive for substances. I read the age description of the offenses there, and if assuming he's the one that actually wrote them, he had a pretty good description of what's going on. But my real concern here is for the defendant's mental health. Sometimes people can acknowledge that they've got a problem, and they can go seek and get that help. And presumably his parole officer would have given him that help or sought that help for him. But he doesn't know until he is caught, until he is facing prison. He doesn't know how to go and get it for himself, and he won't do it. He's going to threaten suicide. He's going to go lock himself into a room. He's going to resist. People here at the jail have to be restrained. When I look at the defendant's criminal history, it started out as a juvenile. A lot of his cases as a juvenile occurred within 4 to 9 months of each other, even while he was on juvenile probation. He kept violating it. He kept running. He ran away from a juvenile home. Then as an adult, well, of course, his adult history is somewhat limited due to the 14 years in prison. But a lot of these offenses occurred while he was on probation. And some of them occurred within 2 months of each other or 5 months of each other. He had one case where he had multiple cases all at the same time. In 2002, he violated bond in 2002. He had a couple cases dismissed, but a lot of his cases occurred right back to back. In fact, he absconded from probation in one file in 2006, committed more probation violations in 2006, and picked up those charges, which are the ones that sent him to prison in that year. And he was, yeah, it took him less than a year from being released on parole to pick up these charges. And these are quite concerning to the court. When he was out, by the way, on parole, he had a job and he lasted 1 month. And because he quit, actually he had 2 jobs, and he quit both of them. I'm sorry, let me take that back. He had 3 jobs and he quit a couple of them back to back. That gives me a lot of concern. And then when I look at his substance use treatment, which began, or substance use history, it says from spring of 24 to when he got caught in December of 2024, he was a daily user of cocaine, methamphetamine, and amphetamines. He got, actually here in November of 2024, it looks like he went to Catholic Human Services but failed to complete that program. He also had education on substance use and abuse while in prison that ended in October of 2023, just a couple months before being released. So I see current probation doing their efforts. I see the prison doing the efforts up until the moment he is released, and he immediately goes back to these bad choices. Now, one of the next things I do is when I look over at CFJ 284, page 17, I see that this goes back to my other concern. My primary concern here is the mental health of the defendant. He has several issues that are, or mental health conditions that are listed here. And they're very concerning. But what's also concerning is the big gap of information. I see 1, 2, 3, 4, 5, 6, 7 entries for mental health. And the only medication I see are 2 drugs for ADHD. I otherwise see nothing about treatment, which is what brings me down to this position. The position here is that the court understands the defendant needs substance abuse treatment. They tried in the prison to set him up before he left. It didn't work. They then tried to give him Catholic Human Services. It didn't work. He got jobs. He quit those. That didn't work. And he was immediately back to possessing firearms and ammunition, which means I'm now less concerned about the defendant, although I am concerned about him personally, but I'm less concerned about his addiction. I'm more concerned about his mental health and the danger he presents to society. If he has any intuitiveness into what his challenges are, I needed to hear less about substances, and I needed to know about his mental health. What medication and treatment is he doing to get his mental health? And these conditions that are listed here, schizophrenia, post-traumatic stress disorder, depression, bipolar disorder, suicidal tendencies, those need to scare the defendant because they definitely are of concern to this court. I'm concerned about his health and safety, but I'm also concerned about other people. And the fact that this assault resist comes about definitely tells me that I need to be concerned as a judge about the protection of society. Now, again, I care for every person that appears in front of this court, and it's not always comfortable to be in the position in which I am today, but I'm here and it's my job. And it's my responsibility to not only the defendant, but also to this community. Therefore, the sentence of this court as to file 3568, count 1, possession of the controlled substance, methamphetamine. The court sentences the defendant to a $68 state minimum fee, a $130 crime victims' rights fund fee. By the way, while the court added the 30 days previously for the contempt, he wouldn't have gotten credit really anyways. It was all largely administrative and formality. But so in this file, the count 1, the court sentences the defendant to 20 to 120 months in the Department of Corrections. And as to count 2, the court sentences the defendant to 18 to 24 months.
Bullshit. You said a bunch of fucking bullshit.
Nope, bring him back. Take a seat.
I'm good. I don't want to fucking hear this shit.
Take a seat.
There's nothing else to fucking hear, man. Get the fuck out of here, dude. Get the fuck out of here. There's nothing else to hear, man. I'm done. I'm done with the sentence, dude. I'm done. Take me back. I'm fucking done, man. There's nothing else to fucking hear, dude. Get me out of here, man. Send me back to the fucking joint. That's it. Get me out of here, dude. There ain't nothing else to talk about. Let's go.
Mr. Wilson, I had to finish this.
I don't give a fuck, man. You're sending me back to prison, dude. I'm good. A bunch of shit what you said was bullshit, man. A whole bunch of it was. The fucking weapons, the ammunition wasn't mine. It was my fucking stepdad's. Never even touched it. You guys could have ran a fingerprint analysis on all that shit, and none of my stuff would have came up on that. Never fucking touched it. Didn't have no firearms, didn't have no weapons. There was no assault. It was a resist. I took off running. That's all it was. No fucking danger to society. I haven't even been in a fight since I've been out. No violent crimes, no assaulted, nothing, dude. Fuck this shit. I'm straight. Take me back, man.
All right.
I'm good. I'm good. Totally good, man.
The court.
There's no sense to listen to the rest of this bullshit.
The court understands the concern and statements expressed by the defendant. However, the court finds that all he's done is reassert that the court has to be concerned about his mental health and protection of society.
You guys don't.
The court is adjourned. Thank you. I'm sorry. They run concurrent to one another. They run consecutive to whatever prior parole sentence is. And there's a $68. No, wait. It's two $68 state minimum fees. Yes, Mr. Denham.
Yeah, just a couple minor points. Ms. Odell informs me that with respect to the second count, it cannot be more than 2/3. So it should be 16.
Yeah, 16. Thank you. I was trying to do the math quickly in my head and I got interrupted. So you're correct. The 2/3 rule makes it a 16 to 24. Thank you.
And the other very minor point, Your Honor, as part of the plea agreement, the other file is being dismissed, but the knife in that file is being forfeited. I just want to confirm that would be part of the order.
That is so ordered.
Thank you.
Is there any jail credit?
No, there's not because he's on parole.
So fucking what? Just sat 125 days, no credit. Man, fuck all you motherfuckers, man. Fuck you, Lord. All you motherfuckers.
Thank you. We're adjourned.